All right, so to help keep all of us from getting arrested or disbarred, we have Major Melissa Ken here to provide us with a ethics CLE presentation. Major Ken is an assistant professor of law with the United States Air Force Academy's Department of Law, where she teaches national security law and law for Air Force officers. Most recently, she received her LLM in national security law from George Washington University with highest honors. So please join me in welcoming Major Ken. The floor is yours.
All right, well, thank you very much for that introduction, Professor Biller. I did not come prepared with jokes, so we're just gonna get straight into the fun stuff of the ethics. So as Professor Biller mentioned, I am Major Melissa Ken, instructor here at USAFA. And before we get running, we have a few mandatory disclaimers. First off, anything that I discuss here today is not legal advice. Okay, please, if you find yourself in a situation where you need an attorney or you need legal advice, this is not the place to get it. Go out and hire your own attorney, get specified advice for your specific matter and for your needs. And then, of course, the views expressed in this presentation are my own and do not represent the official position of the United States government or the Department of Defense. So with those mandatory disclaimers out of the way, this is what we are going to talk about today. So we're going to focus on technology, our professional responsibilities in regards to technological developments and all the technology that we use as attorneys today. I thought that was fitting given the SPACECOM theme. So we'll talk about the ABA model rules. We'll also talk about some COVID implications, as well as our ethics in regards to data breaches. And then professional responsibilities when working remotely. So we'll kick it off with our rules that we're going to talk about today. So the attorney duty, we have competence, confidentiality, supervision, communication, and then we'll talk about securing communications in the context of the ABA Formal Opinion 477 as well. So competence will focus on Rule 1.1, confidentiality 1.6. Supervision will talk about two rules, 5.1 and 5.3, and then communication will be 1.4. So competence. A lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Right, so most of us are familiar legal knowledge and skill. That's part of why we're here, right? To get our ethics credits. There's a comment number 8, which elaborates on this requirement. It says, to maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology, engaging in continuing study, and comply with all continuing legal education requirements to which the lawyer is subject. And so that's why we're here. We all are aware of our CLE requirements. We're here to get our ethics CLE requirement today. Something that we may not be as familiar with is our obligation to keep apprised of the benefits and risks associated with relevant technology. This was adopted in 2012 and now is part of our core obligation of competence to our clients. So understanding both the benefits and the risks of technology in the course of our representation of a client. All right, so confidentiality. Most of us are aware of this rule, of course, but it bears repeating. A client shall not reveal information relating to the representation of a client unless the client gives informed consent. The disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B. So according to ABA Rule 1 Echo, informed consent is defined as an agreement by a person to a proposed course of conduct, after the lawyer has communicated adequate information and explanation about the material risks of and reasonably available alternatives to the proposed course of conduct. And so informed consent doesn't just mean you are making your recommendation to the client and the client is blindly agreeing with it. Having true informed consent from your client means that you are explaining all of the options to your client, all the reasonably available options. and that you are ensuring that they are making a truly educated and informed decision. So part of my background, I was a special victims counsel for 2 years, now just known as a victims counsel. So as a special victims counsel, if my client came into my office and said, you know, I want to go to a court martial, I want to testify at a court martial, I didn't just say, okay, let's go to court. We went through all of the options. We went through what an administrative discharge board would look like, what an Article 15 would look like, what lesser punishment would look like, to make sure that they were truly understanding all of the available options and making an informed decision. So making sure that you're advising them of reasonably available options and alternatives is part of our informed consent requirement of confidentiality. And this is a fundamental principle of our attorney-client relationship, right? Without this confidentiality and this privilege, clients would not have trust in their attorneys. And this trust is essential to our work. If clients can't communicate fully and frankly and give us full disclosure of their situation, their scenario, the factors that are important to them, clients cannot have honest conversations with their attorney. And it's almost impossible to give fully accurate and effective legal advice if you don't have the whole story, right? If you don't know what their objectives are, if you don't know what's truly going on, if your client is withholding information from you, it hinders our ability to effectively represent them. And so this trust and relationship, this privilege, allows us to fully advise our clients and to protect our clients. Disclosure is impliedly authorized if it is necessary to carry out the representation as well. So to attorneys working in a firm, this can include sharing information with other attorneys within your firm, unless of course your client has specifically put limits on this type of sharing. And again, you'll hear a lot of stories about when I was an SVC. That's my primary experience draw for these kinds of things. So that was something that I talked with my clients up front about, was that I would be discussing cases with other attorneys, not specifics, but the general legal principles that were at stake that were being discussed. And I made sure that I had my clients consent to share that type of information with other attorneys in my region and my Chief Circuit SVC at the time. Additionally, disclosure is impliedly authorized if you are admitting a fact that can't properly be disputed, or if you're making a disclosure that facilitates achieving the client's desired conclusion to a matter. So all of these are impliedly authorized disclosures that we are allowed to make pursuant to Rule 1.6 of confidentiality. All right, so we're not going to go through the specifics of paragraph Bravo, but I do want to talk a little bit about paragraph C, which says a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. All right, so in order to understand what this means, we have to explore this reasonable efforts standard and dive into the comments for the rule on confidentiality. And this reasonable efforts standard is something that we see throughout the professional rules of conduct, the rules of professional responsibility, so that we're ensuring that we're making those reasonable steps and taking those steps to prevent unauthorized disclosure. Okay, so comment number 18 to Rule 1.6 of confidentiality says that paragraph C requires a lawyer to act competently to safeguard information relating to the representation of a client against unauthorized access by third parties and against inadvertent or unauthorized disclosure by the lawyer or other persons who are participating in the representation of the client or who are subject to the lawyer's supervision. All right, so that includes, as it says, those who are subject to the lawyer's supervision. And we're going to spend some time talking about the rules on supervision later in this brief. But essentially what this says is that any breach of confidentiality by a paralegal or by a staff member, the consequences of that will flow back to the supervising attorney. We're the ones with the bar licenses. We're the ones with the ethical rules of conduct that govern our behavior. So this comment and confidentiality also applies to technology in related matters and communications, right? We use technology on an unprecedented level now, especially with COVID. Not only are we using cloud-based storage to contain our clients' confidential information, but we're using Zoom meetings to actually have confidential conversations with our clients. And so when we're using cloud storage, when we're using these virtual platforms to discuss important case information with our clients, we need to understand how our ethical duties apply in these technologies. So the reasonableness standard that I was alluding to before. Again, comment number 18 says that inadvertent or unauthorized disclosure of information relating to the representation of a client does not constitute a violation if the lawyer has made reasonable efforts to prevent the access or disclosure of that information. Okay, so on the, let me get my left and rights correct. On the right-hand side of that screen, we have some factors that are considered when determining whether an attorney has made a reasonable effort to prevent the access or disclosure of information. Okay, this is not an exhaustive list, but factors include the sensitivity of information, the likelihood of disclosure, the cost of employing additional safeguards, the difficulty of implementing those safeguards, as well as the extent to which those safeguards adversely affect or impact the lawyer's ability to represent clients. And again, this isn't the end-all be-all of the list of factors, but as long as you make sure that you're considering the sensitivity of your client's information and the rest of these factors, it'll give you a good idea of how to maintain your ethical responsibility of confidentiality under the professional rules of conduct. All right, so additionally, a client may require their lawyer to implement special security measures that aren't normally required by this rule, or they may give informed consent to forego security measures that would normally be required by this rule. So again, informed consent, that doesn't just mean, oh, I don't care if you don't encrypt my stuff. I don't care if you send my stuff over an open Wi-Fi network. I don't care how you do this. You have to inform them of the risks that are inherent in not encrypting, the risks that are inherent in using open Wi-Fi, which goes back to Rule 1.1 on competency. We have to understand those risks and we have to understand those benefits inherent to these various technologies that we're using. And there may be additional laws, such as state laws that are specific to where you are licensed, that may impose additional requirements. And these are all things that we need to be aware of on a case-by-case basis to make sure that we are properly adhering to our ethical duties and advising our clients of the ramifications of their decisions. All right, so as an instructor, I love giving my students thought questions. I'm not really expecting any interaction, anybody to share their thoughts, but I would like you to get your wheels turning and to actually put some thought into these questions. So we've talked briefly about our video platforms, our virtual platforms, where we communicate with each other in office meetings, we communicate with clients. How does these duties that we've been talking about, how do they apply to remote client communications on platforms such as Zoom? And additionally, can we use open Wi-Fi networks to engage in these confidential client communications? So I'll give you a minute to think about that. All right, so in my research, I found that regardless of the type of platform, whether it's Zoom or something else, that the same ethical duty exists to take responsible measures to prevent the inadvertent and unauthorized disclosures. I'm going to use Zoom as an example because that's what I'm most familiar with personally. We've all heard of Zoom bombings, right? Especially when COVID first kicked off. We had people who were signing into meetings, whether they were office meetings, whether they were court hearings, whatever the meeting was, people who weren't supposed to be there were signing in and listening in to these meetings. And Zoom responded to this by putting extra security measures, making extra security measures available for meetings. For example, the meeting host can add a password requirement or a waiting room requirement to make sure that only authorized users are actually getting into the meeting. But do not assume that Zoom or whatever platform you're using is automatically applying these security measures for you, right? Or even that they're applying the highest level of security to your meeting. Depending on the content, what's being discussed, you might need to increase the security, add more options in addition to the default options that Zoom gives you or whatever platform you have. And that, again, ties back to our duty of competence. Not only do we have to use these features, or in order to use these features, we have to understand what features are available. We have to understand the security settings available on the platforms that we're using and make sure that they're properly applied. And another thing to be aware of when we're using video platforms, is there anyone else in the physical room with you? Virtual conference room aside, is there anybody physically in the room with you or with your client, right? This is something that's more difficult to verify on your client's end, but be aware of the privilege implications if there's a third party in the room, and consider re-advising your client of the limits on the privilege and the ramifications of having someone else in the room. I think it's natural. I had a lot of clients who wanted to have their parents present or their best friend present or whoever present during conversations with me, their attorney. And every single time I advise them, attorney-client privilege is exactly what it sounds like. It's the cone of silence, as it was explained to me in my law school professional responsibility class. Right? And so by bringing in that third party, by adding somebody to that conversation, you are risking your protections and privilege that's inherent with the attorney-client relationship. So even when you're on a Zoom platform, if your client tells you there's nobody in the room, you still might want to consider re-advising them of the implications of having somebody else in that room. But what about the open Wi-Fi question? We're talking about non-password protected connections. So ones that you would find at the library, at Starbucks, at the airport, where you don't have to put in any additional security information, you just plug and play. Are these okay to use when conducting confidential client communications? And the answer is that state bars and ethics experts have repeatedly recommended not to use open Wi-Fi. It's probably best practice to avoid using open Wi-Fi in general. It offers the least protection, and it's the easiest to hack, the easiest for someone to steal your information. Information can be intercepted and decoded, which would expose those confidential and privileged communications, which can lead to malpractice claims, increased insurance costs, professional responsibility violations, and other repercussions. It's also sometimes difficult to know when you've been hacked, when that information has actually been taken, and if someone could continue to hack you depending on what kind of information they've taken from you, which could result in additional damages. So previously, when we were talking about our reasonable efforts factors, we had the likelihood of disclosure if additional safeguards are not employed. So using open Wi-Fi directly contradicts that reasonableness, right? The likelihood of disclosure on open Wi-Fi is higher. It's inherently riskier. And so it cuts against your reasonable efforts to protect your client's information if you are knowingly using an open Wi-Fi connection. Now, of course, there is a caveat, because what's a rule without an exception? If you must absolutely have to communicate with your client, and the only option is an open Wi-Fi connection, then this cuts towards reasonableness, right? It likely won't constitute a violation of your professional obligations, because if you do not make that communication, there will be an adverse impact on your representation, which was another one of those reasonableness factors that we went through. All right, so if you absolutely have to communicate with your client, and the representation will be adversely impacted if you do not make this communication, then it is not a violation of your professional responsibility rules to make that communication. For example, if you're working in the criminal context and you have a prosecutor call you and say, we have a plea deal, but it's only available for the next 30 minutes, right? You're stuck in an airport. The only Wi-Fi you have is an open Wi-Fi connection. You have to make this communication now to make sure that you're fulfilling your obligations of communication to your client so that the client has the opportunity to take advantage of this plea deal if they want to. But even if it is the only option, you must be careful that you're only communicating what is absolutely necessary and that you're not giving additional information over that open Wi-Fi connection. So again, if you're communicating that plea deal to your client, you can communicate the terms, but you probably shouldn't say, in previous conversations, you told me that you totally did this, so you should take the plea deal and run, right? That's additional unnecessary information that your client doesn't need to receive over an open, unsecure Wi-Fi connection. All right, so generally do not use unsecured open Wi-Fi. If it's absolutely necessary, you can communicate that information with your client, but be sure you're not giving additional unnecessary information over that unsecured connection. All right, and again, with Zoom, make sure you understand, or whatever virtual platform you use, make sure you understand the privacy settings, the additional security measures that may be necessary given the content of your meeting, and make sure that they're all properly applied and in place before you start that meeting. Oh, I forgot to show my Wi-Fi picture, I'm sorry. All right, so moving on to supervisory responsibilities. Rule 5.1, the responsibility of a partner or a supervisory lawyer. Okay, paragraph A says that a partner shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that all lawyers in the firm conform to the rules of professional conduct. Paragraph A goes on to say that a partner includes members of a partnership, shareholders in a law firm organized as a professional corporation, members of other associations authorized to practice law, lawyers having comparable managerial authority in a legal services organization or in a law department of an enterprise or government agency, and lawyers who have intermediate managerial responsibilities in a firm. Paragraph B says that a lawyer having direct supervisory authority over another lawyer shall make reasonable efforts to ensure that the other lawyer conforms to the rules. All right, and so in comment number 2, we have a little bit of elaboration on this. We have, again, that reasonable efforts standard to establish internal policies and procedures designed to provide reasonable assurances that all the lawyers in the firm will conform to the rules of professional conduct. All right, so what kind of policies are we talking about here? What kind of procedures can we put in place to make sure that all lawyers in a firm or all lawyers that you supervise are actually conforming to the rules of professional conduct? So comment number 2 specifically enumerates a few of these policies that we should have in place, and they include detecting and resolving conflicts of interest, right? This is going to be particularly important in law firms, something that we do in base legal offices. We want to make sure that people do not have inherent conflicts of interest when we are assigning them cases. We also, the rules recommend implementing policies and procedures to identify dates by which actions must be taken in pending matters. So setting those expectations, letting attorneys that you supervise know what your expectations are as far as completing pending matters, when they should have certain milestones completed. That we should also have policies accounting for client funds and property, as well as ensuring that inexperienced lawyers are properly supervised. So setting up those mentoring relationships, making sure that when you get a junior attorney or a baby jag in your office, that you're not letting them run free and rampant, that you're making sure that they have a mentor, somebody that they can talk to, someone that they can learn from, who's more experienced to help guide them and ensure that they're conforming to the rules of professional conduct. In regards to non-lawyer assistants, right? Rule 5.1 is about how senior attorneys mentor junior attorneys and make sure that other attorneys in their firms are complying with the rules. Rule 5.3 specifically addresses responsibilities regarding non-lawyer assistants. So subsection A says that paragraph A says that partners shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that the person's conduct is compatible with the professional obligations of the lawyer. As well, any lawyer having direct supervisory authority over the non-lawyer shall make reasonable efforts to ensure that the person's conduct is compatible with the professional obligations of the lawyer. And if a lawyer is responsible for the conduct of a person that would be a violation of the rules of professional conduct, if engaged in by the lawyer, then the lawyer can be held accountable for this behavior. And I think we're all familiar with these standards, but it's important to give that reminder that a lawyer must make reasonable efforts. Again, we keep seeing this throughout the rules: reasonableness, reasonableness, reasonableness. We have to provide appropriate instruction and supervision concerning the ethical aspects of employment, particularly in regard to the obligation not to disclose information relating to the representation of the client. So we have to keep in mind that paralegals and non-lawyers and other staff members, they haven't gone through law school professional responsibility classes. They didn't take the professional responsibility exam. It's us who put our licenses at risk. And so it is imperative and part of our reasonableness, our reasonable efforts, that we train them thoroughly and from square one. We shouldn't always assume prior knowledge, even if you have an experienced paralegal. Again, because it's your bar license that's at stake. Training is important, but I think we know that no training scheme is perfect. And even if it was, human error is always going to enter the equation. If misconduct occurs, and even then, an attorney is not necessarily going to be punished unless you ordered it, then that's on you. If you directly told somebody to violate the rules, that's a no-no. But if you didn't know about it when it was happening, then the question is whether you ratified that conduct. And that's what paragraph C talks about. If the attorney ordered or ratified the conduct, or if a partner or supervisor knows of the conduct when the consequences could be avoided or mitigated, but failed to take reasonable remedial action. So did you find out about it and just decide to do nothing? Is pretty much adopting the behavior as your own? Or did you try to fix it and make it better? And as long as you take reasonable steps to remediate that damage, then you won't be held in violation of the rules of professional responsibility. A little bit deeper into the duty to supervise, comment number 3 says that when using services outside of the firm, a lawyer must make reasonable efforts to ensure that those services are provided in a manner that is compatible with the lawyer's professional obligations. Okay? And these services include things like hiring a company to manage your documents, or to create and maintain a database for complex litigation. Sending client documents to a third party for scanning or printing or shredding at the end of the case, as well as using internet-based services to store client information, if you use the cloud, for example. So the extent of our professional obligation here depends on the circumstances and who you are actually contracting with. What services outside the firm are you contracting for? And what is the reputation and experience of that service or the non-lawyer providing the services? We also have to consider any terms of arrangements concerning the protection of your client's information. So if your client has asked explicitly for additional protections, or if they have asked you not to use certain services, even if that would normally be okay, your client maintains that control over the representation and maintains that control over how their information is stored and how their information is shared. So if your client asks for that extra protection, or if you're aware of a need for increased protection based on the nature of the information, if it's bank records, if it's medical records, those might need a little bit more protection and a little bit more security to ensure and prevent the unauthorized disclosure of that information. Moving on to Rule 1.4, the duty to communicate. And this seems to be the most common complaint against us lawyers, that we don't seem to like to communicate with our client. But the rule is very specific about when we need to communicate with our client, and that we need to keep them promptly informed of any decisions or circumstance with respect to which the client's informed consent is required by these rules. So the first thing that comes to mind with this one is settlement offers, right, and plea deals. Even if it's offensively low and you dismiss it out of hand, you still have to communicate that offer to your client, even if it's going to upset them, and even if you know they're going to reject it out of hand. That communication has to take place. Subparagraph 2 talks about how the attorney shall reasonably consult with the client about the means by which the client's objectives are to be accomplished. And this kind of has an underlying requirement too. You have to understand what your client's objectives actually are. Sometimes their goals are different from what they expect, or take into account some unknown consideration, like a business venture they're planning to engage in, or family matters, or other future plans. Sometimes clients don't even know how to articulate their goals. And it's on you, it's your obligation as an attorney to make sure that you are understanding those objectives so that you can reasonably consult with your client about the means to accomplish those objectives. I had a couple clients, one in particular, who thought that they wanted a court-martial because that was the only way they knew and they heard of somebody being held accountable for a sex assault offense, a sex assault allegation. However, after I went through all the options, again, informed consent, telling your client what all the reasonably available options are, my client decided that they wanted an apology letter. That accomplished my client's objectives, not necessarily going to court-martial, because they realized that their true goal was to have that closure, to hear the person apologize, not necessarily to go through the whole court-martial process. So helping your client realize their true objectives, giving them the necessary information, informing them of all their reasonably available options, and giving them that space and time to make an informed decision will allow them to communicate that decision to you better, to articulate those objectives. And if you know their objectives, then you're better able to advise them. And I found, and I think many studies have found, that this allows them clients to communicate better and increase their satisfaction with the process and increase their satisfaction with you as their attorney. So they're less likely to bring these complaints about duty to communicate. The next one says, keep the client reasonably informed about the status of the matter. And sometimes we forget that this includes telling a client when a motion for continuance has been granted, when there's been a pause, and we saw this a lot during COVID. Sometimes attorneys were not advising their clients just that things had been put on pause. And that is really important information for your clients to know, that things are going to be delayed, even though there's no actual movement in the substance of the case. That counts as giving them an update on the status of the matter. Additionally, the rules require that we promptly comply with reasonable requests for information. Don't ghost your client. If your client asks you a question, give them a timeline, right? If you can't get back to them immediately, if you don't know the answer, let them know that fact and give them an estimate as to when you will get back to them. But radio silence is very concerning for your clients. If they're asking a question, and this gets to subsection 5, if they're asking a question that you can't answer, or they're asking you to do something that's unethical, let them know the limitations on your representation. Let them know when they're expecting assistance that's not permitted by the rules of professional conduct. So again, communicating those expectations, communicating those limits on your behavior with your client will satisfy your duty to communicate under the professional rules. All right, so moving on to our ABA formal opinion. This was regarding how to secure communication of protected client information. And the pertinent part of the opinion that I pulled says that a lawyer generally may transmit information relating to the representation of a client over the internet without violating the model rules where the lawyer has undertaken reasonable efforts to prevent inadvertent or unauthorized access. However, a lawyer may be required to take special security precautions to protect against the inadvertent or unauthorized disclosure of client information when required by an agreement with the client or by law or when the nature of the information requires a higher degree of security. And again, we see this reasonable effort standard. We see that we have to take those steps to ensure that we are preventing the inadvertent or unauthorized disclosure. This opinion also highlights special security precautions. So again, if your client has specifically requested that you take additional steps to protect their information, it becomes part of your ethical duty to do so. If the nature of the information, even if it's something that your client hasn't specifically asked for, but again, if it's information of a more sensitive nature, and you know that the information needs additional security or additional protections, then we are obligated to provide that higher degree of security and take reasonable steps to protect that sensitive information. All right, so another thought question: what are some precautions, maybe some best practices that we can take in regards to protecting our client information and ensuring compliance with Formal Opinion 477? So I'm sure all of you know that when it comes to cybersecurity and protecting ourselves against malicious cyber intrusions, that sometimes the most basic steps offer the greatest protection. So antivirus software, encryption, not using open Wi-Fi, using a VPN instead. If you're working from home, make sure that your own personal network is password protected. And this next one is something that I don't do such a good job of myself, but regularly change your passwords, right? Sometimes on government systems, we have a requirement to change our password every so often. But when it comes to our other systems that don't impose that obligation on us, it's hard to remember, and we don't want to change our password because it's ingrained in our minds. But regularly changing your passwords make it more difficult for somebody to intrude on that system and to hack your account. In a similar vein, do not use the same password for all your accounts. Again, very basic steps, but there's a reason we say this. Some people do it. So make sure that you are using different passwords for your accounts, for your tech, and that you are providing this type of training and education to the people in your firm, to the people in your law office, so that they understand how to spot a potential malicious intrusion, so that they know how not to introduce vulnerabilities into the system. So some of the most basic cyber hygiene steps that we can take offer us the greatest protection and will ensure compliance with Formal Opinion 477 to make sure that we're taking those reasonable steps, reasonable efforts to prevent unauthorized disclosure or inadvertent disclosure of our clients' confidential information. All right, so what about the implementation of this duty of technological competence? So we have this duty of technological competence, which I mentioned was introduced into the ABA model rules in 2012. The states, not all 50 states have adopted that duty into their own model, into their own rules yet. As of a couple days ago, 39 states have adopted this duty of technological competence into their rules. And some states have even gone further than simply reiterating the duty of competence as the model rules have done. Some states have started introducing mandatory technology-related CLE requirements. Specifically, Florida requires 3 CLE credits every 3 years. North Carolina requires 1 technology-specific CLE credit every year. And Delaware has imposed a requirement for new attorneys to take a course called Fundamentals of Law Practice Management, Law Practice Management and Technology class. So we already have 2 states who have imposed an affirmative CLE obligation for attorneys to get educated on technology-related issues. We also have some movement in this area. Maine has revised its CLE rules to reflect the importance of technological competence. They have not yet imposed a CLE requirement, though. And New York is considering adding a requirement for 1 credit in cybersecurity to their CLE. So make sure that you're tracking whatever individual state bar that you are a member of. Make sure that you are tracking these potential changes and what might be next in technology-related and mandated CLE requirements for your state bar. All right, so what about legal obligations during COVID? Hopefully, we're out of the weeds with COVID. I love that none of us are wearing masks right now and that we're able to safely do that. But regardless of what comes next, whether it's a variant, whether it's something else, whatever craziness happens, professional responsibilities and ethical duties are not suspended. Attorneys are expected to put client interests ahead of their own personal interests or issues, even COVID-19 related issues. And so we still, our ethical duties of competence, diligent representation, communication, confidentiality, those all persist throughout whatever crisis we are experiencing. Excuse me. So I have a few citations up here. Smith v. State Bar, that was clearly pre-COVID, but the court there said that even in the face of serious personal problems, an attorney has a professional responsibility to fulfill his or her duty to their clients and to make appropriate arrangements to protect their clients' interests. The ABA Special Committee on Disaster Response and Preparedness says that even during a crisis, attorneys remain bound by ethical obligations and must protect their clients' interests. An ABA Model Rule 1.1, which is our competence rule, comment number 3. I was not aware of this before preparing for this presentation, but sole practitioners, the duty to our clients in crisis is so strong that sole practitioners have to prepare and set up backups in the event of their demise, their untimely death, right? To prevent client neglect. In the event of the death of a sole practitioner, each sole practitioner must designate another competent lawyer to review client files, notify clients, and take appropriate protective action if necessary. So the bottom line here is that these duties continue. No crisis is going to suspend an attorney's ethical obligations to their clients. There are some steps that we can take to make sure that we ensure continued operations during an emergency. Making sure that we establish internal and external messaging regarding the firm's ability to operate is one of those best practices. Basically, make sure that people know where to access information, who to talk to, and set those expectations. How long is it going to take to get a response from leadership? How long should it take you to be responding to your clients? Additionally, we need to make sure that we are maintaining record management during these times, ensure that incoming documents are accessible and that they're stored securely, and that not only are they stored securely, but that you can access them. For example, if the emergency situation requires you to work from home, that you can access them and that you have secure access set up from home. The prioritization of tasks, make sure that you're keeping track of court appearances and litigation deadlines. During COVID, a lot of that meant we were moving for continuance, or we were waiting for the judge to decide when a case was going to be continued and reheard. So we have to make sure that we are keeping on top of those requirements. Be prepared for virtual hearings if a judge decides to go virtual instead of in person. And of course, in accordance with our duty to communicate, keep our clients informed of any continuances or any changes in the case. And identifying leadership to answer questions, this kind of ties back to the first one. Make sure people know who to talk to and where the best source of information that they have is going to be. All right, data breach ethics. So another ABA formal opinion 483. So this opinion states that an obligation exists for a lawyer to communicate with clients about a data breach. Now, however, not all cyber incidents are created equal. Not all incidents require client notification. So the opinion specifically says and defines a data breach as an incident in which material client confidential information is misappropriated, destroyed, or otherwise compromised, or where a lawyer's ability to perform the legal services for which the lawyer is hired is significantly impaired by the episode. So there's no notification required if your client's information has not actually been misappropriated or accessed in an unauthorized way, unless, of course, as the caveat says, if your services are significantly impaired. However, if you have a reasonable suspicion that your client's information has been accessed by somebody who's not authorized to do so, then you still have to make that notification and inform your client of the potential loss and the potential unauthorized access. Now, the last point there is a reminder that our duty is to disclose. Of course, as previously discussed, we have an obligation to take reasonable efforts and reasonable steps to protect and prevent our client's information. But the fact that you are the victim of a data breach does not mean that you are in violation of the professional rules of conduct, right? But if you are the victim of a data breach, despite your best efforts, and many, many people are, you must ensure that you inform your clients when their information is reasonably suspected of being taken or when it's actually been taken, lost, or accessed in some way. So here are some numbers on data breaches according to the ABA 2021 Legal Technology Survey Report. And this surveyed law firms and solo practitioners. 25% of those surveyed reported a data breach. And incredibly, 6% of that 25 didn't even know the consequences of their data breach, the extent of the damage, what had been taken, what had been accessed. Only 36% of those surveyed had an incident response plan. Only 24% notified clients of a breach. And 32% of those surveyed didn't even know, period, if they'd been impacted by viruses, spyware, or malware. So in order to prevent potential data breaches, the ABA encourages and recommends firms to establish security policies, right? We should all have an incident plan, a plan as to how we are going to respond in the event that we are hacked. But in addition to that, to prevent hacking from happening in the first place, we should have security policies in place, similar to these basic cyber hygiene steps that we were talking about earlier. And in the survey, 17% of those who responded didn't have any security policies in place at all. And you can see the statistics and figures in regards to email use, internet use, remote access, and things of that nature. But the best practices and the recommendations from the ABA are to make sure that we have these response plans and security policies in place. Not only that, but that attorneys understand the nature of cybersecurity threats, that we understand, again, going back to that duty of competence, how technology can both add and subtract. Understand how your client's information is transmitted and stored. Don't just trust somebody in your IT department to take care of that. The duty of competence requires that we have a basic understanding, at least, of how these communications are transmitted and stored. Additionally, we should not just understand, but we should use reasonable electronic security measures and determine how electronic communications about client matters should be protected. The next one's pretty simple, but actually label your information as confidential. Make sure that you're putting the appropriate tags on your documents and on your confidential communications. And train lawyers and non-lawyer assistants in technology and information security. Okay, we have to make sure that that they are complying with the rules of professional conduct, and that any non-lawyer services, any third-party vendors that we contract with, that they are also providing that security in communication technology. All right, so a few tips on professional responsibilities while working remotely. This is something that we are all familiar with, something that we've probably done a lot of over the last couple of years, but it bears repeating. So we have to ensure that we are maintaining good technology practices. Make sure you bring your laptop charger home from work. Make sure that you are using, again, that secure personal network, a password protected Wi-Fi connection or a VPN. And that you have access to necessary files and client-related data from home, and that you're able to access those files and data in a secure way. When we're working remotely, we got to still keep track of that calendar, still make sure that we're keeping appointments, court hearings, filing deadlines, all of those good things, that we are managing our time well and not losing track of things just because we're working from home. Being mindful of court and agency hours. Sometimes if you're not physically in the building, it's easy to kind of forget when certain agencies are closed. So, if you're working on a court martial and you need some medical records and you forget that the med group is closed every Thursday for training and your filing deadline is on Friday, it can get a little sticky, right? So make sure that you are tracking those hours when people are closed, and that you're giving yourself a buffer so that you're not down to the wire, so that you're not cutting it close on filing deadlines and your other obligations. Again, maintain client communications, the duty to communicate. Make sure that clients have your duty phone number or your email address, and that not just your clients can reach you, but that your staff can reach you. And set those expectations. How long is your response time going to be? Are there certain days of the week when you know you have other obligations and you're not going to be able to communicate with them as quickly? Just communicate those expectations. Let them know when to expect longer response times. Let them know how to reach you, and maintain those communications even when you're working remotely. And the last one is snail mail. People do still receive important documents through the mail. And so if you're out of the office for an extended period of time, make sure that you've made arrangements for that mail to be forwarded to your location, or maybe scanned by somebody who's still working in the office and sent to you over a secure platform. So we have some additional device security practices and takeaways. Again, a lot of us are using personal devices and networks to manage sensitive or confidential information. And again, the vast majority of data breaches are not caused by technology, but they are allowed by human error and a lack of training. So at minimum, reasonable efforts to protect information when using your own devices to do work at home include these basic cyber hygiene practices. Make sure that you're installing those systems like antivirus, that you're using encryption, that you have a firewall, that you're using VPN, and that all of your people, all of those staff members are also getting this cyber awareness training, so that when they're working from home and using their personal devices, that you're taking those reasonable steps for not just you, but everybody under your supervision, to have these basic protections against unauthorized disclosures. And again, due diligence for vendors, make sure that they have adequate training, adequate testing, and that these conversations with your vendors, and having these conversations with your vendors protects your duties and obligations under these rules. One big thing working from home is basic email etiquette. Again, sometimes it's the most basic things that protect us the most. So don't open links or attachments from people that you don't know. If you weren't tracking that, that's one of the most common ways to introduce vulnerabilities into a system, is to open those unknown emails and click on links. Hackers can find information about us and send an email that makes it seem like they're a prospective client, like they're involved in your business in some way. And so understanding what these phishing schemes look like and training your people on what they look like can go a long way in protecting folks and making sure that we are preventing unauthorized disclosures. A best practice that's recommended is to implement spot checking tests. So send emails, have your IT department send emails to people in the firm and see who clicks on it. See who's adding those vulnerabilities into the system. And then it's done in a low threat way. You can see what kind of correction and education needs to happen. Most of these are basic education issues. People don't know what they don't know. And so providing those trainings and the basic cyber awareness can go a long way to fulfilling your ethical duties to prevent unauthorized disclosures and taking those reasonable steps to prevent unauthorized disclosures. So with that, I will turn it over to any questions.
Thank you so much, Major Ken. Really appreciate it. We do have a question from virtual world. That question is, how do you communicate with courts and kind of the judicial administration in a safe and ethical way? I believe this is coming from someone potentially overseas. They noted that they have a special lawyer's system with cards and double checks to communicate with officers of the court. What would be your technological recommendation for communicating with courts and administration?
Yeah, that's a great question. And I think in typical lawyer fashion, I'm going to say it depends, right? It depends on your specific state. It depends on your court's practices. But I think the main basic takeaways from our ethical obligations are to take those reasonable steps. So if there is a specific platform that we're supposed to use as required by our state courts, then that can fall into an obligation imposed on us by law or imposed on us by our state. But the basic reasonable steps that we have to take as attorneys to fulfill our professional responsibility and ethical duties are to make sure that we are utilizing additional safeguards as necessary, that we are using, especially when we're online, that we're using protected Wi-Fi, that we're using VPN, and that we are taking the additional steps as necessary to ensure that our confidential communications, whether they're to a client or whether they're to a court, that we are taking all the reasonable steps that we can to prevent unauthorized disclosure and unauthorized access. All right.
Thank you very much.
Thank you.